Did you know that blocking the entrance to a church, mosque, or temple is now treated with the same severity as a major federal crime? Why is this important? Here's the law. Rising anti Semitism, Islamophobia, homophobia, and transphobia have left too many people feeling unsafe in their own communities. Someone spray paints a swastika on your community center. Someone blocks the door to your place of worship. Someone posts hateful content online that incites violence against your community. You feel powerless. But wait, you're not as powerless as they would like you to believe. The Canadian government has just enacted the most significant anti-hate legislation in a generation. And a second bill is working its way through Parliament to tackle online hate. So, today we are going to break down exactly what these laws do, how they protect you, and what you need to do to stay safe. Let's start with the law that is already in effect. On June 18, 2026, the Combating Hate Act, formerly Bill C-9, received Royal Assent. It came into force on July 18, 2026. This is not a small change. It fundamentally reshapes how Canada deals with hate-motivated crime. Here's what it does. Number one, it defines hatred for the very first time. For the first time in Canadian criminal law, hatred is formally defined. The Act codifies the definition previously developed by the Supreme Court of Canada. This gives police and prosecutors a clear legal standard to work with. Number two, it creates standalone hate crime offenses. Before Bill C-9, prosecutors needed the Attorney General's consent to lay charges for hate propaganda offenses. That requirements have been removed. Hate crimes can now be prosecuted more quickly and more effectively. Number three, it criminalizes public displays of hate symbols. It is now a criminal offense to willfully promote hatred against an identifiable group by displaying certain symbols in public. These include symbols associated with listed terrorist entities under the criminal code. The Nazi swastika and SS bolts, for example. The news, a symbol of anti-black racism and lynching. Number four, it protects community spaces. The Act creates two new offenses. Offense number one, engaging in conduct with the intent to make someone afraid in order to prevent them from accessing a religious or cultural institution. This includes threats, acts of violence, or other intimidating behavior. Maximum penalty for this offense is 10 years in imprisonment. Offense number two, obstruction. Intentionally blocking or interfering with a person's lawful access to places of worship, schools, community centers, or other spaces primarily used by identifiable groups carries a maximum penalty of 10 years in imprisonment. Protected places include synagogues, mosques, churches, temples, cemeteries, and spaces used by identifiable groups for administrative, social, cultural, or educational purposes. This act respects Canadian charter rights. The act is carefully designed not to apply to people who are simply communicating information, peaceful protesting, or otherwise not engaging in criminal activity. Now, let's talk about the bill that is still working its way through Parliament. On June 10, 2026, the government of Canada introduced Bill C-34, the Safe Social Media Act. It's currently at first reading. It will need to go through committee, amendments, and debate, but it does signal where the government of Canada is heading. Why does this matter? Online harms are not just the result of individual behavior. They are shaped by how digital services are designed and operated. Features such as the algorithms recommendation systems, engagement-based feeds, autoplay, and endless scrolling can amplify harmful content and increase exposure, particularly for young users. The statistics are sobering. 1 in 4 young aged 12 to 17 have experienced cyberbullying. Youth who experience online victimization are significantly more likely to report poor mental health outcomes, including suicidal ideation. Police reported incidents of online child sexual abuse and exploitation have increased significantly. The bill targets 7 categories of harmful content, and they are intimate content, communication without consent, content that sexually victimizes a child or re-victimizes a survivor, content that induces a child to harm themselves, content used to bully a child, content that foments hatred, content that incites violence, and last but not the least, terrorism or violent extremism content. 3 core duties are now in play. The legislation imposes 3 duties on regulated services. 1, duty to protect children. Social media services and AI chatbots must implement age-appropriate protections and safeguards for younger users. This includes an age restriction prohibiting children under 16 from having social media accounts. That last bit is going to be tough to implement and enforce, but there's going to be more to be said about that later. Number 2, duty to act responsibly. Services must access and mitigate risk of exposure to harmful content. Number 3, duty to make certain content. To make certain content inaccessible. Services must rapidly remove content that sexually victimizes a child, and intimate content shared without consent is a problem. Now, let's talk about enforcement. The bill creates a new Digital Safety Commission of Canada, an independent regulator charged with administering and enforcing the regime. Penalties are quite significant, up to $10 million or 3% of global revenue for administrative penalties, and for criminal fines of up to $20 million or 5% of global revenue for the most serious offenses. Now, a note of caution. The Justice Center for Constitutional Freedoms has launched a national campaign opposing Bill C-34. They argue that it could force Canadians to surrender more personal information to the government or foreign social media companies. As the bill moves through Parliament, there will be vigorous debate about balancing safety with privacy and free expression. Legislation is only part of the solution and not the only solution. The government also recognizes that Canadians need the skills to recognize and respond to online hate and misinformation. The Digital Citizen Initiative and its Digital Citizen Contribution Program support projects that increase digital media and civic literacy across Canada. So, since January 2020, the program has provided about $8.6 million in funding to third party organizations. What does this funding support? It supports developing tools to support digital media and civic literacy, preventing and addressing online violence against women, girls, and the LGBT communities, building tactical and technical capacities among civil society organizations to address mis and disinformation, hate speech, and cyberbullying. What does this all mean for you? It means you're not alone in navigating the online world. There are resources and organizations funded to help you develop the skills to spot misinformation, protect yourself from hate, and stay safe online. So, to sum up, here's the law and here's your move. If you witness hate motivated intimidation or obstruction, report it to your local police. If you see harmful content online, report it to the platform. And once the Digital Safety Commission is operational, report it to that commission. If you want to improve your digital literacy, explore the resources funded through the Digital Citizen Initiative. And if you are concerned about how these laws affect your privacy or free expression, get informed. Read the bills. They're online. You can find them. Contact your MP. They work for you. Engaged in the constructive debate leading up to the finalization of this bill. Canada is taking hate seriously, both offline and online. But the law only works if we use it.